I'm going to make just a few points expanding on what Senator Kerry had said so well. Coming back to first principles, everybody learns in the first year of law school, if a law is challenged, it is presumed to be constitutional. That is a heavy burden for anyone challenging the constitutionality of a law to overcome. When in doubt, uphold the law. Basic first principle of constitutional jurisprudence. There is a lot of room for doubt here, and there is a lot of clear precedent that requires this court to uphold this law. In only 2 instances in modern history has the court struck down any federal law based on Commerce Clause challenge. In both, for example, the gun case involving restrictions on guns close to school, the laws were local and non-commercial. Local and non-commercial. This law clearly affects the national economy. It involves a fifth of the national economy. The court would not only have to stretch, it would have to abandon and completely overrule a lot of modern precedent, which would do grave damage to this court in credibility and power. The court commands no armies. It has no money. It depends for its power on its credibility and its reputation. Ultimately, people obey it because it has that credibility. And the court risks grave damage if it strikes down a statute of this magnitude and importance and stretches so dramatically and drastically to do it. Now, the one thing I can tell you, I think with pretty near certainty, is the court hasn't made a decision. There are at least 3 justices who haven't made up their minds. I say that based not only on having argued cases before the court for them and having been a law clerk, but also having talked to justices over the years. They come away from these arguments questioning each other and themselves. And you saw that in every day so far, that they were still questioning, still thinking and deliberating. So I think all of the predictions are worth what you're paying for them. They mean nothing at this point. And the questions, I can tell you also, as Senator Kerry said so well, are in no way indicative of how they may decide. In fact, some justices actually ask questions that are contrary to where they may be going, simply either to be inscrutable or to test the other side of the argument. That's the whole purpose of oral argument. And the final point I would make is the court has to be aware that Americans don't want to go back to the days when insurance companies made the rules, denied people coverage, when young people could not stay on their parents' policies until the age of 26. Americans do not want to abandon all of the very specific, profoundly important benefits that have already been achieved as a result of this law. And their role in a limited constitutional system is not to reach the hypotheticals. They don't need to decide the broccoli hypotheticals. What they need to do is decide this case. They don't need to establish a limiting principle for the Commerce Clause. Their role is to decide these issues case by case, not establish rules of law, which is what is done in that building, not the one in back of us. And for the court to strike down this law would be to presume the powers of the Congress and abandon its role as an impartial and deliberate decider of constitutional law. And I don't believe the court will go there or should go there anyway.